Okay, well, hello everybody. Sorry we're running a little bit late today. It's about 2:37 on Friday. Welcome to our frequently asked questions. We had some technical difficulties. That's why we're back to using an iPad to broadcast here. So we'll try to speak up a little bit so people can hear us, and hopefully by next week we can have our camera equipment and audio running well again. Today I want to introduce Will Privette. Say hi to everybody.
Hello, my name is Will Privette. I've been an attorney since 2012. Been working with Herrman Herrman's office for about 3 years, and I've been doing this type of law, personal injury, for the better part of 5 years now in South Texas.
Okay, and so the topic today is the reasons that we terminate cases. And so, Will, I know you kind of prepared for this. So, why don't you give the people an idea of why it is we terminate the case, or give the file back to them?
Sure. I'll give a couple reasons here of why we have to sometimes make the unfortunate decision to let a case go. Insurance is a big part of it. Oftentimes when we're trying to settle a claim with the adverse party, it's not actually the person we're going after, it's their insurance company, their automobile insurance. So, you're required by law in Texas to carry insurance to protect others if you get into a wreck, but unfortunately sometimes people don't carry that insurance. So bodily injury coverage, that would be what's considered a third-party coverage. Your first-party claim and the person who hits you would be the third-party coverage. So sometimes the other person doesn't have insurance, and that's very unfortunate, but that can be saved if you yourself carry certain types of insurance on your own policy. Those most notably are underinsured motorist coverage or uninsured motorist coverage and personal injury protection. Those are what's called first-party forms of insurance. It's between you and your own insurance company. So if you get into a wreck caused by somebody that doesn't have insurance, those policies of insurance will be there to protect you and make sure you have monetary compensation for pain and suffering, for medical bills that you've incurred. So that's why we always harp, it's very, very important and not that expensive to get underinsured motorist coverage and personal injury protection. If you have those, no matter what wreck you get into, no matter what the other party has, you're going to have some coverage there.
Do we know what percent of people are running around that they're without coverage, without liability coverage?
I would guess it depends on your neighborhood. The better neighborhoods are going to have a higher percentage of people with coverage. Your little less nice of a neighborhood is going to have probably a higher percentage of no insurance. But I would say in Corpus, most of the time people have adverse insurance. I would say about 10 to 15% of the time you find that there's no insurance on the other side, and that's always a difficult conversation to have with the client.
Okay. And you didn't mention MedPay. I know there's something called MedPay too.
Yeah, medical payments is also one of those first-party coverages. It's on your own insurance. It's a little bit different to personal injury protection. Basically, medical payments works the same way as personal injury protection, but if you ever received money from the at-fault party, you basically have to pay back the medical payments insurance funds, but if personal injury protection, you don't have to pay it back. So you get offered, underinsured motorist, personal injury protection, and even MedPay. It's, in my opinion, personal injury protection is much, much better than MedPay, and very, very little difference in terms of cost. So I would always suggest to have at least the minimum policy for UIM, which is the uninsured motorist, and at least the minimum for personal injury protection. And those limits, the minimums are $30,000 of coverage for the underinsured motorist and $2,500 for personal injury protection. That's the minimum that Texas can write a policy for.
Okay, so sometimes we sign a case up and we think it's decent, and then we go to check and there's no insurance. Client doesn't have UM or UIM, doesn't have PIP or MedPay. There's no adverse. So that would be one reason that we just wouldn't be able to help them. What are some other reasons we might have to give a file back to somebody?
Well, there's a few others. One of these terms of art, I guess you could call it, is the proverbial he said, she said collision. Inconsistent statements between our client and the other driver in the vehicle, or in the other vehicle. I'm sorry. There's always two sides to every coin, and there's two sides to every story. If the defendant, in our case, we're the plaintiff, we're trying to get money from the defendant. If the defendant says that they were not at fault for the collision, if they say that the plaintiff's at fault, and the police report doesn't really say one way or the other who's at fault, in Texas, we have, as the plaintiff, you have the burden of proof. So that's where this is important. You have to prove your case. So the defense, if you don't bring any evidence to prove that the defendant did anything wrong, the defense can rest their case or file for a motion for summary judgment during trial. You have to bring evidence, you have to bring facts, you have to bring something that proves the defendant caused the accident. Otherwise, you're not going to be able to recover for that accident. And that's another one of those situations where we as a law firm, we want to help every single person that we can. We want to help every person that walks through the door. But, we're a business, and it costs a lot of money to get to the court. So without evidence, sometimes we have to let cases go. In Texas, Texas follows the modified comparative fault rule. So basically, as the plaintiff, we have to prove that the defendant was 51% or more at fault. If the defendant is 51% or more at fault, then we can collect money for the case. If we're deemed 50% at fault, we cannot recover. We're barred from recovery. So that's one of those things that the he said, she said cases, sometimes we have to let those go if we don't have any witnesses, if we don't have any evidence. That's why at the scene, we've put out some really good dicta. We've got a book here, and we've got a pamphlet that everybody should have in their car that says what to do right after a wreck. And one of those things is gather any photos that you can. Gather any witnesses at the scene, including phone numbers, because they might not remember, and it's going to be hard to get them after the fact. There's a lot of things that you can do to preserve a case right at the scene, at the time of the accident. That's why it's important. You go to our website. I think our pamphlet's on there. Our book is on there. Read through it, because the last thing we need is these inconsistent statements causing us to term a case or get rid of a case that we really don't want to. So we need that evidence. Evidence is very, very important. And so without evidence, these inconsistent statements can be very, very difficult to overcome.
So you're not saying just because the other guy says it's not my fault, y'all are going to give him a file back there?
No, definitely not. But we need evidence to overcome their unwillingness to cooperate, because people lie. People lie. Defendants lie all the time, and so that's why it's good to have some pictures. If you've got a rear end collision, they might try to lie and say it's not your fault, but generally speaking, if you're rear-ended, the other person that rear-ended you is at fault. But if it's one of those where you've got somebody turning this way and the other person turning this way, and you both claim you have a green light, and the insurance company is saying that they're gonna believe their client over our client, then there are some factors to determine whether it's a valuable or a viable case for litigation. But a big one that you need to get over is liability. That's the biggest step. If you can't have proven liability, it's going to be a very, very hard case to win.
But isn't that your job as a lawyer to get the evidence? You're telling me I got to collect the evidence before I even come?
Well, it would help for you to gather the evidence at the scene, because sometimes evidence disappears. Sometimes a car will get fixed without us getting photos. This is one of the books we were talking about, 7 fatal mistakes that will ruin your case. I wrote one of the chapters in here, 7 chapters about what to do and what not to do about your car wrecks. But yeah, it is our job, and we do collect the evidence, but we can't create evidence. We can't created out of thin air. So if there is no evidence to support our case, the defendant has a little bit, they don't have to prove it. The defendant doesn't have to prove their side. We have to prove our side. So I'm not saying that we term every case with inconsistent statements, but we need evidence of the traffic light patterns. We need evidence by way of an independent witness. We need photos that would, that would line up with the story of our client's story, but without anything, with our client's word versus their client's word, and no evidence to support it. It might get past the motion for summary judgment. It might be a question for the jury, but it's not something that, most firms don't want to hang their hat on a coin flip when they've got thousands and thousands of dollars and potentially years of time invested in a case.
All right. So what clients should do is make sure they talk to all the independent witnesses. Don't just assume the police officer's going to get all these people.
Definitely.
And he should take photos of the scene, maybe take photos of the driver, maybe take photos of the sequence of traffic lights. And we can always go out and do that ourselves. We can take pictures of the traffic lights, unless they change the pattern for some reason. And we can get the diagram from the city. But as long as they're there and they can see what whether it goes to green arrow, green light, whether it's yellow before that or with a yellow arrow, they need to take those kind of photos, right?
Yes.
And if there's anything blocking any intersection or blocking anybody's vision or blocking the stop sign, anything like that, a tree or a car or whatever, they should take photos of all that too, right?
Yes, sir. All that stuff will definitely help.
No, what if you're injured and you got to go directly to the hospital and you don't have time to be out there taking photos of light sequences and stop signs and skid marks and type thing?
Well, this is all kind of, I guess, if you're in a collision that is severe enough that you're needing to go to the hospital, a lot of times, more often than not, at least in Nueces County, the cops are going to come and they're going to write a report. This type of case that we're talking about, these inconsistent statement cases, this he said, she said, either the cop couldn't determine what happened on the police report, or maybe there was no police report at all. If it happened on private property, the cops will oftentimes not write a police report. If it happened at an apartment complex, somewhere where it's not a main thoroughfare. So those are kind of the cases I'm talking about. If you're injured enough to where you're going to the hospital, more often than not, there's going to be a police report, and that police report in and of itself is generally enough evidence that we need, because it's happened many times that even with a police report that says the defendant's at fault, they lie even still and say that the police report's wrong.
Yeah.
And that's the type of case where that evidence is going to be, in my opinion, more insurmountable than just the word of our client and the word of the defendant, because we have something from an independent party that deemed the other person at fault.
Yeah.
And so that, I don't see it a whole lot on cases where they go to the hospital, because there oftentimes is a police report on a collision that severe.
I know we have people sometimes call us from the scene of the accident. Is that a good idea?
I think that's definitely a good idea, because, if anything, if you don't have a copy of this book, which you can get at the website, you can go to hermanandherman.com and get a free copy of this book. And I think the pamphlet's on there. I would really recommend you get a copy of that and put it in your glove box. But yeah, if you don't have a copy of this and you don't know exactly what to do, I think it's definitely important to call an attorney first, at least to know the proper steps, where you should go, what you should do. If you're hurt, you obviously go to whatever doctor you see fit. If you don't have health insurance, that's something that we can help at least get the ball rolling for you. We have providers that can see you depending on what your needs are. So it's definitely important to call an attorney first, I would say. I would say call Herrman and Herrman first, because we do a great job and we do the best for our clients. So yeah, I think it's good to call.
Well, if they call us, we'll actually send somebody out there right away, right?
We'll send somebody
taking photos immediately.
Yeah, we'll send somebody, not to be intrusive, but if you want, we can send somebody straight to the scene when you're out there. We could send somebody to the hospital if you have to go to the hospital and you want to talk to legal representation right away. We're very accommodating. We have on-call phones. You ask some of the attorneys, myself included, we might not love that after hours, but we have it. So we're available 24/7. If you ever have a call, if you ever have a wreck, if you have a question about an injury or any type of case that you might need a lawyer, feel free to call us, 882-4357, and we'll talk to you anytime, day or night.
Okay. What else do you have on your?
Well, I've got one more here I want to talk about, and this one's a little sensitive, but sometimes the plaintiff themselves, our own client, can ruin a case. And it's part of our contract, it's part of our sign-up process. We want to explain to you guys, to the plaintiffs, potential plaintiffs out there, social media can ruin a case. It really can. And if you don't think the adjusters and these people are out there trolling the internet, they most certainly are. And they will find you doing jumping jacks or cartwheels or going skiing or doing something and basically
smoking marijuana.
Yeah, smoking marijuana, drinking in excess of alcohol, anything to damage your character, your veracity for truthfulness, and anything that could make you look bad, basically, they're going to try to find. So, if you're posting on social media, you're going to spring break and you're drinking all sorts of beer and you're posting pictures with a joint, they're going to talk to the jury and to the people listening to your case about your ability to be truthful and your kind of shady demeanor. And so it's always good to keep pics and videos off of social media that would hurt your case. So like I said, if you're if you're saying to us and to the defense that you have a knee injury and then you're out there doing splits and doing cartwheels and jumping all up and down on that knee and dunking a basketball, then the defense counsel is going to try to get a hold of that evidence and try to diminish the value of your case.
Well, and the argument I hear made a lot of times is, look, alcohol's a neurotoxin, and you probably could have healed quicker had you not been out drinking and stuff. Did the doctor tell you it's okay to go drink beer while you're injured and while you're trying to recover? And
yeah.
Had you not been doing drugs and not been drinking, you probably would have recovered all the way, or you would have recovered faster. And that's why judges sometimes let that in, even though it seems like, hey, judge, why should this come in? It doesn't make sense. And it'll come up on a cross-examination of the doctor. They'll say, well, doctor, isn't that a neurotoxin? Do you think that's a good idea for a client to be drinking that while he's trying to heal? And, doctor will have to say, no, he really should. Would he have healed better and faster had he not been doing drugs and drinking, doc? And the doctor's going to go, yeah. So now it comes in?
Yeah. Yeah, and no doctor's gonna obviously tell you to drink heavily or smoke marijuana to get over any injuries
or do any other drugs.
Yeah, or do any other drugs. So, but anything like that, anything that hurts your outward appearance to the jury or to anybody, that's negative. Another thing is, and that part, that talks to the damages of the case. That doesn't necessarily affect the liability portion. But in every case that we deal with, it's a negligence claim. So you have 4 elements. You got duty, breach, causation, and damages. So the defendant had a duty to drive their car in a reasonable manner. They failed to meet that duty by rear-ending you, and that rear-ended caused your damages. And so that damages element, if you're posting videos doing jumping jacks and climbing Mount Kilimanjaro, then your damages are going to be significantly diminished. Another way that you can ruin your case, plaintiff, and you can ruin the liability portion, is by inconsistent statements. And it's a little different context than what I was talking about earlier. In this context, I mean, you're plaintiff. You get hit by somebody else. That before you go to a law firm, you talk to their insurance company and you tell them what happened in the accident, okay? And then you say, oh, I'm a little more hurt than I thought I was. Maybe I need an attorney to just make sure I'm not doing the wrong things. And then you give another recorded statement, either through deposition or written statement, and those 2 statements are inconsistent, then your case is going to be ruined. And that's going to be a reason that we need to get rid of a case. And and back to the social media stuff, if your videos and your postings are so bad for the case that it ruins the case, then those are reasons, somewhat minor, not as often as the first two reasons we talked about, but those are reasons that we would have to also, unfortunately, get rid of a case, for our firm.
Okay, and there's some others that you can do to ruin your case that are in the book. So again, everybody read that. Let me just say it's getting kind of late. We've already kind of spent more time than we normally do. So next week we may or may not be on live. Next week is Fiesta de la Flor. Herrman Herrman is a proud sponsor of Fiesta de la Flor. If we don't do one here, we may be over at the American Bank Center getting ready, and so we may do a Facebook Live over there. Just a reminder, we got Becky G. If anybody knows who Becky G is, she's going to be new talent at the Fiesta de la Flor this weekend, and she's pretty phenomenal among all the other artists. So I hope everybody can make it out there. And until next Friday, goodbye, and well, want to say goodbye?
Yep, bye. Thanks again. I'm sure I'll see you again for another frequently asked question. And until next time.
Yeah.